profitable across the whole of SAA's network for the most sustained period of time. At that point in time, Emirates was threatening to renegotiate that basis of that agreement, so it would have threatened even SAA's only profitable code share arrangement at that point in time. So it was important that we conducted ourselves with integrity in those discussions and negotiations, and to the extent that we opted to not pursue what was proven to be a financially viable partnership in the case of, for example, Qantas and Emirates, that we at least owed a duty of care to provide to our partners a reason. And we were incapable as a management team to provide a reason, because the only reason that was forwarded to us by the chairperson of SAA at the time was a fear of theft of South Africa's wildlife. And the second point was the insinuation that Emirates were to acquire SAA. Both of those issues were fully addressed and canvassed. There were at no point in time any legal reasons forwarded by the SAA chairlady, and that after the deal construct was reviewed by her own legal advisor as well as SAA's own internal legal advisor.
Okay. Now, my line of questioning wasn't going there, but this issue is occurring, and I think I should deal with it now. This allegation that you made, the former chair had concerns about wildlife and so on, can you prove that?
It was a direct statement made by the former chairperson of South African Airways to myself. I'm not sure whether she may have made it to others as well, but it was a direct statement made to myself.
There's another persisting allegation that you make that the chair had fears or expressed fears along the lines of the airline being sold or being bought by a. Do you remember that?
Yes, my lady, I do.
Now, I'll ask you to go to page 3. It's the start point of a letter from the chairperson to the Honourable Minister Nene. It is dated the 13th of February 2015. Do you find it?
Yes, my lady.
Now, if you can come with me then from that start point to page 7 thereafter. And I'll count paragraphs for you. The 4th paragraph, I think it's got the first bullet point after paragraph A. Do you see that?
Yes, my lady, I do.
Sorry, did you see the bullet point that what starts with SAA is aware? That's the 4th paragraph at the bottom.
Yes, my lady, I wrote that paragraph.
Was this not a letter from the chairperson to the minister?
My lady, it was signed by the chairperson. It was edited and written by myself.
This entire document?
The entire document. And it was signed by the chairperson of SA and then transmitted. And as I reported yesterday, one of the key reasons why we appointed an executive in the chairperson's office, which was not done before or after Ms. Myeni, was to make sure that accurate information gets to the shareholder.
Now the question is, she's got her signature, her initials there.
Yes, she does.
So then this document is attributable to her, and nowhere does it appear in this document that you worked on this document. Do you see that?
My lady, yes, it was signed by her, and it's common practice. Please bear in mind that the SAA chairperson is, in theory, meant to be a non-executive chairperson. So therefore, it would be customary for all chairpersons of all companies, private or public, that often letters and reports would be generated by the executives. And to the extent that protocol calls for it to be submitted to a shareholder by the office of a chairperson, the chairperson would then, of that company, would then evaluate the substance of the letter in front of him or her, and then sign that letter if it carries their concurrence, and then submit it through to the shareholder. There's a very specific protocol in state-owned companies that a CEO of a state-owned company cannot communicate to a minister. The CEO of a state-owned company can communicate to the Director General, the chairperson of the board would communicate to the shareholder, and the substance of that communication would often be drawn from the executives, as it was in this case.
Are you then saying this letter is not a letter from the chairperson to the minister?
My lady, it is a letter from the chairperson to the minister. It was a letter authored by myself, reviewed to the satisfaction of the chairperson of the SAA board, as indicated by her signature being attached thereto.
Are you then saying the chairperson then aligned herself to these comments?
I can't speak on the chairperson's behalf. I would assume that if it's before the chairperson affixes her signature to any document, that she aligns herself to that content.
Thank you. Now let's go to that fourth paragraph. It says, SAA is aware of the approach received from Emirates, brackets, which is not an equity approach and merely represents an expansion of the existing 15-year-old SAA code share agreement. Do you see that?
Yes, my lady, I do.
So, on the face of it, and this is what the evidence is before the court, the chairperson addresses a letter to the minister saying explicitly that this is not an equity approach. Do you accept that?
Yes, my lady, I do. If I may also just state that this exact case provides evidence of the inconsistency in Ms. Myeni's behavior. And I'll offer a further example of it. Ms. Myeni, for example, approved a press release, and multiple press releases for that matter, stating that, and categorically admitting that it was SAA's mistake to make certain claims about my studies. Yet, 5 years later, in papers that served in front of this court submitted by your office, then states, I claim false studies. Perfect inconsistency. In this specific case, Ms. Myeni stated, I drafted the letter, but Ms. Myeni made it her own, stating and admitting that there is no equity claim. Yet, there is various minutes, subsequent board minutes, and further indications of Ms. Myeni then stating in other forums that her concern is the company being bought by Emirates.
Okay.
Be that as it may, we did address it in the agreement to make sure that that concern of hers were addressed.
See, the challenge we've faced here is that what you say doesn't concord with the evidence before court. I'll start here. You say this letter is drafted by you. There's no evidence before this court to say that. You drafted this letter. So there's no basis upon which we can accept that, or why that version must be preferred over this version, where she's got not only her signature. Yes, I'm putting a proposition to him, though. But, my lady, I'm saying I'm putting this proposition to him initially to get his view on it, to say, well, based on that, the reason I say this proposition in particular is because there are a lot of unproven statements that you keep making that are not forming part of the evidence that you want to preferred over documentary evidence that is before court. Thank you, madam. Yes, madam. Well, when we get there, madam. When we get there, yes, madam. Okay. All right.
You see, where I was for the tangent here, I was saying to you that we do not agree with your submission that
The failure or the refusal to sign the MOU
on the 16th or the 15th of June, as it was, is what led to the collapse of the deal.
My lady, if I may add,
Yes.
that to the extent that the veracity of my claim is brought into question by counsel as it relates to the authorship of this letter, I submit that I have evidence of drafts circulated, and I'm happy to submit it to the court in any which way is may be required. I'm also aware that there will be a multitude of further witnesses during this proceedings, and it's a commonly known fact. Ms. Myeni did not keep it a secret. It was not a discussion that she only had with me in terms of the fear of Emirates wishing to acquire SAA, and therefore a multitude of witnesses may also be tested.
Okay, that wasn't the question I put to you, though. The question I put to you was this. The non-signing of this agreement on the 15th of June, as it was, did not result in the collapse of the deal.
My lady, factually, having been involved in the process, I disagree with that assertion, but I'm welcome to be enlightened.
Okay. Then, if that is the case, I will ask you to go to page 191B. I think it forms. It's still in the same fundament. Yes. Or perhaps, yeah, let's start with 191B. Okay. This is to SAA board from acting SAA chief executive. Was that yourself at the time? Oh, sorry, that's the resolution 119C, sorry.
Sorry, 191?
C, the next page, sorry.
Yes, my lady, this is a report from myself to the SAA board on the 6th of July. This was obviously 3 weeks after the MOU was meant to be executed and the MOU in its settled form being contained in your bundles.
Yes. Now, if you go to the end of that document, which is 191H. Oh, sorry, before we get there. The last, 191G, paragraph 9. It's the last page before the last page. Okay.
Yes, I've got it, my lady.
It says, paragraph 9, recommendation, right?
Yes, my lady.
It is recommended that the board approve the non-binding MOU between SAA and Emirates Airline prior to its execution by management. Do you see that?
Yes, I do, my lady.
That was a recommendation by you.
Yes, my lady.
And on the next page, there's a signature that appears next to your name. I'm not too sure if it's yours, but
Yes, it is mine, my lady.
you see, this is the problem now. Because if on the 15th of June, this transaction collapsed, we wouldn't have got to the stage on the 6th of July where you write a request to the board to approve the MOU.
My lady, as my testimony yesterday was, when we arrived at the signing venue on the 16th of June, which I do remind my lady that it was at least the second aborted occasion to try and execute this agreement. When we arrived and events fell apart after having received an instruction not to execute the agreement, after having received a 2 a.m. in the morning call from Ms. Myeni, which claims it was an instruction from the President. At that point in time, I had an engagement with Sir Tim Clark, and Sir Tim Clark, as I reported yesterday, agreed to keep the negotiations active, despite the fact that we have again failed to execute this non-binding MOU.
And that's the point. And that is the point. The negotiations did not collapse.
My lady, there was no further negotiations after that. This was a good faith effort on the part of Sir Tim Clark to keep the negotiations open despite every single attempt taken by Ms. Myeni to have these negotiations aborted.
I don't agree with you, sir, because you've got a lengthy submission to the board on the 6th of July, okay, where you're asking the board to approve. And if you start at 191A or 191B, 6th of July, if you go to 191B, sorry, just go back slightly. It says at the top, SAA Board of Directors, written resolution number 215/B44, SA Emirates Airline non-binding memorandum of understanding. Purpose. The purpose of the submission is to request the board to approve the non-binding memorandum of understanding between SAA and Emirates Airline prior to its execution by management. Do you see that?
Yes, my lady.
So-
This is the round-robin resolution that Ms. Myeni also stopped.
Well, is there any proof that you stopped that?
Yes, my lady. There's an email correspondence in the bundle that we covered in the last couple of days where Ms. Myeni states that a round-robin approval is not acceptable. She does not agree with it. It is in the evidence bundle. It was covered in the last 24 hours.
Well, it was just in your absence, it was submission of your counsel as well, or sorry, not your counsel, the counsel of Outer, that these round-robin resolutions were problematic, but I'll get to that for argument. But the point of the matter is this following issue, is that this issue was still live on the 6th of July.
No thank you to Ms. Myeni, and not to, and my lady, if I may state, it is a simple matter of fact that the proposal was received on the 22nd of July. The proposal required an MOU to be executed in order to take negotiations further. And today, as we sit here 5 years later, the MOU had not been executed and there's no further agreement in play.
You see, the case we've come to meet is the following, is that you received a call while you were in Paris and told not to sign this agreement. And as a result thereof, the whole deal fell through.
My lady, my evidence is very specific. It is not the specific date of the 16th of July not executing the MOU. It is failure to execute the MOU over a prolonged period of time. The 16th of July was one date in time. Before that, there was the 10th of June in Miami at the IATA AGM. So there were various different dates, not the 16th in specific.
Well, that's what you say, but the case we've come to meet is the case that says on the 16th of June, were it not for the call that you received while you were in Paris, this transaction would have gone through.
My lady, I do not profess and nor am I in a position to frame the case that you're coming to meet. All I can do is provide the evidence in fact as they existed. And the reason why this agreement was not executed was the critical and needed step before executing a final agreement, that being the execution of an MOU, was stopped by one person and one person only on multiple times, Ms. Myeni. That is my evidence. In as far as the case in front of the court, that is my contribution.
We say, and I'll take you to your own evidence thereafter, is the following. It's inaccurate to say the non-signing of 16th of June collapsed this transaction. And I'll now take you further to show you this point. If you go to page 203. Same bundle, Marita.
No, I don't.
I'm sorry, Marita. It's compressed in mine. Did you find it's an email?
203, yes, my lady.
It's an email dated 5 August 2015.
Yes, my lady.
At that time, from what I can read here, you were no longer acting CEO.
No, I was not, my lady.
Right. And this is an email from Sylvain
Yes,
to Limshe. So
yes, my
you
lady.
may not comment about it, but it says the following. At the bottom, it says, can you please request COSEC to run an urgent round robin on this one? Are you see?
Yes, I can see that, my lady.
This was still being round robin in August. Do you see that? After you'd left.
Yes, my lady. It was the process on, obviously, the whole notion of finding a business partner in the Middle East was a matter that survived any individual CEO's term in office. It was a matter that emanated from SA's long-term turnaround strategy accepted by Parliament, thereafter contained in SA's business corporate plans, approved in multiple years by multiple ministries and multiple ministers holding office. And obviously, therefore, it was expected to be driven by the executive team of SAA going forward. The unfortunate reality is that I was a key driver at some point. Thereafter, Sylvain was a key driver. Thereafter, Tuli was a key driver. Thereafter, Wolf was a key driver. Thereafter, Barry Parsons was a key driver. And the one consistent we've got throughout all those individuals is that Dudu came for all of us. Dudu Myeni stated to me when I left back to Mango that you cannot go hide behind your thumb at Mango. And that is the unfortunate correlation that I do see in these emails.
Can we go to page 206, please? It says summary of discussions between SAA management and the Department of Transport officials, which took place on Friday, 7 August 2015.
I see the page, my lady.
Now, it states the following in the background. After learning that the potential expansion of SAA and Emirates' existing commercial cooperation agreement was getting more coverage in the media, the board had resolved to establish and review the task team, to review the draft SAA MOU. The board affirmed its support for the spirit of the MOU. Also, Emirates was still keen on concluding signing of the MOU with SAA. Do you see that?
Yes, my lady. So may I comment on this? A couple of things.
Well,
There's
before
one.
you do so, sorry, I wanted to make this one question. 7 August 2015. This meeting is summarized with the following terms. Emirates was still keen on concluding the signing of the MOU with SAA. Do you see that?
Yes, my lady, I see that.
Now, what this point then says to me is that this didn't collapse in June.
My lady, if I may respond. So, again, for the record, the date at which it was not a singular instance or a singular act on the part of Ms. Myeni. It was a consistent pattern of behavior and actions taken in this matter as well as others, but for the time being in this matter. So the 16th of June, the 10th of June, the 10th of June, the 16th of June makes no difference. It's a continued process. Second point I want to make on this piece of paper in front of me, whilst I am unaware of who the author is, and as Council correctly pointed out, I was no longer in the company at that point in time or in SA. The one thing that I will point out is that the very first sentence is factually inaccurate. The first sentence says, after learning that the potential expansion of SA and Emirates' existing commercial cooperation arrangement was getting more coverage in the media, that only is when this operational review task team was formed, which is factually incorrect. This operational task team was formed after the board meeting of the 28th of May. So on the 29th of May, Ms. Myeni then issues the instruction that this task team must be created, and that predates the media coverage of the 20th of June by 21 days. So the reason why the task team was created was not in response to media coverage, and furthermore, it would be quite illogical to create a task team in response to media coverage, but the task team does not contain a single person who's got any media experience, or as a spokesperson, or as a media expert. So factually, that first sentence cannot be correct in my reading, because I do not know who the author is or what the context is of it.
That's fine.
And therefore, I can also not attest to any accuracy in any of the rest of the sentences in that paragraph.
Okay. Then let's move to the next page. If you dispute that, which is page 207. Now, that's a letter from the Minister of Transport. Do you see that?
Yes, my lady, I see this.
And it's addressed to the chairperson.
Dated the 8th of August, correct, yes.
Yes. And this is what this letter says. This serves to confirm the Department of Transport's role and position with regards to the national carrier, South African Airways. Do you see that?
Yes, my lady.
Now, if you go, you skip the next big paragraph, and then there's one after that. There's one that begins with the words, with regards to Emirates.
My lady, I just want to check, is this the page that ends saying, however, the department regard these matters as operational and commercial for the airline's management and board? That page. Page 208?
No, it's at 207.
207. So it's the page that ends at the bottom where the DOT makes it clear to SA that the Emirates relationship is an operational airlines matter, not a DOT matter. Yes, I'm on that page, my lady.
Well, I'm not too sure it says what you say, but
I can read it again, my lady. It says, with regards to Emirates, the department...
Yeah?
But I'm just on the same page. It says, with regards to Emirates, the Department of Transport has no objection to SA discussing and or signing any memorandum of cooperation which has to do with the national carrier's turnaround strategy and intent for Africa. However, the department regard these matters as operational and commercial for the airline's management and board. That's
Yes.
the page in front of me, my lady.
Thank you. You see, this is the issue. This negotiation was still live in August.
My lady, with due respect, the Department of Transport has no insight in terms of what it states here is a discussion and negotiation between the two airlines. Now, again, the fact of whether or not these discussions were still alive or not alive, the reality is that Ms. Myeni vacated her position somewhere in 2017, another 12 or 18 months later. The MOU remained unsigned. Now, I do not know and profess to know what the reasons were, but an old adage in life is that the future tends to look like the past. And the past that I can attest to was Ms. Myeni blocking the transaction.
Thank you. You've just made my case for me. I really appreciate that. You see, you've just said it now. You've just said it. You have just said it. And I'll tell you what you've just said. You said you do not know why the MOU remained unsigned.
My lady, yes, correct. I think that when these proceedings, or before this morning, the only two reasons that I could ever proffer why this deal was not signed was Ms. Myeni stating to me that she cares about the wildlife in our country, and the second point being that concern that Emirates would be buying equity in SA. Now, this morning, my lady, counsel provided a version that stated that Ms. Myeni may or may not have said to me anything about live animals, and Ms. Myeni may or may not have claimed ownership of, or actually Ms. Myeni, the evidence stated or point made was that Ms. Myeni said to the minister that she does not believe Emirates wants to buy a stake in SA. We also know that Ms. Myeni at no point, for example, made the statement or raised concern that Emirates is trying to circumvent bilateral rights. So as I sit here today, the only two reasons that I could logically put forward has now also been removed. So now, honestly, I have zero reason or understanding as to why Ms. Myeni blocked this.
You see, the question I put to you, the thing I was saying to you is the following, is that after the 16th of June, the process continued. And after the process continued, you don't know why this was not signed.
I don't know before the process, before I left, apparently, and I don't know after I left. Ms. Myeni never took...
Indeed, Madam. The point I was saying is that after your time, the 16th, you submit a proposal on the 6th of July for the board to vote on it. Is that correct? On this proposal?
This was a various number of proposals submitted. The 6th of July was one of them.
Yes, to get board approval.
Yes, my lady.
Which then, the conclusions of that then are leave for argument. Now, let's continue. The next email is on page 209, dated...
Miss, my lady, may I just make a point, since you pointed me to page 207. Yes. I think that in yesterday's deliberation, there seemed to have been some confusion that SAA is at liberty or have any power to assign bilateral rights. I think this page 207 also again speaks to the fact that the Department of Transport has sole rights to sole right and responsibility to assign flight rights between carriers. It was something that was also a known fact because in the various submissions that I've made to the SAA board, I actually included the bilateral air services agreements between the various countries.
You see, we're getting to it just in a couple of pages because I said it to you yesterday that Emirates wanted SAA support for its fourth frequency. That's all this was about. All that SAA wanted was fourth. And I'll take you to...
My lady, the reason I raise it is that yesterday my lady made the statement that it was an unlawful agreement. And it was pointed out that that was a fairly serious... My apologies, my lady. Yes, the council made the council made the statement that it was an unlawful contract, and my lady pointed out that it was a serious accusation to make. And when the national flag carrier and an organ of state is being accused of unlawful actions, it is a serious matter. Obviously, it's a serious matter for individual citizens too. And I needed to just point out there that SA at no point pursued, to my knowledge, as far as it relates to this Emirates matter, pursued any unlawful action other than to try and avoid a drainage of the national fiscus.
Okay, we'll get to that point. Let's get to that email on 209. You may or may not have a view on this, and I'm told this witness will testify, but I just want to bring your attention what he says. Mr. Twala, in my understanding, is the gentleman from the Department of Transport who had written to you earlier on the 23rd of June. Do you remember?
I do not remember the specific individual that wrote on the 23rd of June, my lady.
Sorry to send you back and forth. Okay, nothing turns on that. Let's just move on. But it's the letter that
Look,
appears
it was my understanding that the earlier letter was written by the Director General. I understand Mr. Twala to be a Deputy Director General, but
That's neither here nor there. The point is here. This is what Sylvain says to him. The subject is SAA Emirates MOU. This is on the 11th of August. It says the following. As agreed, I would say at our last meeting, I am sending you the latest version of the SAA Emirates MOU, which was to be signed during Paris Air Show.
yes, my lord.
He says the latest version, which was to be signed. So, his address is DOT, which is... No, he's coming, man. He's coming. No. That is not my intention. I want to display to this witness one point and one point only. That the specific MOU that was due to be signed in Paris was still being discussed in August.
My lady, again, just for emphasis, because I think that maybe my messaging isn't clear. For absolute emphasis, my testimony is not that Ms. Dudu Myeni killed the transaction on the 16th of July. My testimony is that she approached it through a Stalingrad type of defense throughout and stymied the transaction at every single possible opportunity up to the time that I had left, and not specifically the 16th of July. And all this further evidences is the fact that to the extent that somebody may take a view of saying this was Nico's transaction, he wanted Emirates. It's not Nico wanting Emirates. All that this shows is that multiple management before me, management after me, was diligent in trying to pursue what was a prescribed action in SAA's corporate planning documents and accepted legal documentation. So that is my testimony. The preoccupation on specifically the 16th of June is not something that I have introduced.
Well, that's correct, if you haven't introduced it. And I can't hold you to accountable to that, but I'm just placing it before you that you testified in the preceding days that it was that call that said to you, President Zuma says, don't sign this deal, which then collapsed this transaction and cost the airline money. Was that not correct?
My lady, my specific statement is the proposal made to SAA entailed a $100 million minimum revenue guarantee. That proposal to come to fruition required a path to be walked. You had to walk past the MOU as a path in order to arrive at the end point. What Ms. Myeni ensured is that that requisite path could not be travelled. And as a consequence, the proposal that contained a revenue benefit of $100 million never came into fruition, and no other reason has been proffered as to why it hasn't come into fruition other than this MOU not being executed. And the only person that stopped this MOU from being executed was Ms. Myeni. That is my sole evidence.
Well, that's your evidence, but the problem we've got with that evidence is that it's not supported by anything at all. After the 16th, we'll okay. I wasn't done yet, my lady. I'd like to take you to an email. Sorry. A letter, page 217. a letter dated 8 September 2015. Do you see that?
It's-
217, sorry, my lady, I beg your pardon. 217. 217. Dated
Yes, I'm
8
there, my lady.
It's a letter from Emirates addressed to Tulim Shea, Acting SAA Chief Executive Officer. Do you see that?
Yes, my lady.
Now, at the third paragraph, okay, it says the following. Emirates were quite shocked to receive this response. Oh, this is a response to a letter from the minister. Or maybe do you want to start there so that we have context? Page 215, sorry. 215.
Yes, I'm there, my lady.
It's addressed to Mr. Abbas by Minister of Finance Nhlanhla Nene on the 2nd of September 2015.
Yes, my lady.
Do you see that? And it says, Dear Mr. Abbas, the title is Emirates South African Airways Commercial Partnership. And he says, I refer to your letter dated 30 August 2015 regarding the above mentioned matter. As indicated in your correspondence, this is an operational matter which should be dealt with at management or board level. The shareholder does not get involved in matters of this nature. There is a specific issue, unless there is a specific issue which may require the shareholder's endorsement. Do you see that?
Yes, my lady.
Now, let's complete the sentence, my lady. That was the next sentence, my lady. Yes. Good. If you now go to page 217, this now places context to what this letter was in response to. Yes. Because what Emirates is shocked at here is that response that we've just discovered at 215. Now,
Yes, my lady, and if I can provide context, whilst this letter is dated...
thank you, madam. Thank you. Thank you. It says, Emirates were quite shocked to receive this response, brackets, and frankly, so quickly, close brackets. I fail to see any remaining issues in regard to SAA fulfilling its current commercial obligation and requesting that the Department of Transport formally withdraw their right of appeal in regards to Emirates' fourth daily Johannesburg frequency. Do you see that?
Yes, my lady.
Now, the question to you. All right. Likewise, there should be no remaining impediment to immediately executing the South African Emirates SAA Memorandum of Understanding to develop an enhanced commercial partnership. Do you see that?
Yes, I do, my lady.
Now, I'm persisting with the allegation that I'm saying to you. This is 3 months later. As Emirates is still calling for the signing of the MOU. Do you see that?
Yes, my lady, and still Ms. Myeni was blocking it.
Well, we'll argue there's no proof, but the point I'm saying is that what this defeats is the allegation that this thing died in June. Now let's move to the next point.
Sorry, excuse me, my lady, I missed your last...
I'm saying what this proves or defeats is the allegation that the non-signing of this in Paris in June, it defeats that, it collapsed the transaction. But I'll argue that at a later stage. Now we go to page 218, the next page.
My lady, what this also may be, since we are on this page,
Yes.
in terms of Emirates being shocked, yes, Emirates was right to be shocked, because here the minister, shareholding minister, states to Emirates that this is an operational matter. It's always been an operational matter. And the ministry has been consistent throughout, from the 22nd of January onwards.
Yeah.
Emirates then also states then, well, what is the reason for the MOU not to be signed? It could be signed right now.
That's correct.
And it equally then also emphasised the fact that it would require SAA to provide support for purposes of its fourth element. So all this shows is the same confusion as I have as I sit here today in this witness box, that why can you not proceed on this?
You gave the answer before. You said you don't know why this wasn't signed.
I don't know why Ms. Myeni's reasons. So, my lady, just for clarity's sake, I 100% know why it was not signed. I got a direct instruction not to sign it, and I got that instruction from Ms. Myeni. So I do know why it was not signed. As to what could have informed Ms. Myeni's thinking, that I do not know. And for the moment, if we are taking away the notion of Emirates investing in SA, I would venture a guess to say that none of the other board members could equally have known at that point why Ms. Myeni bestowed upon herself a singular veto right on executing this MOU and issuing, and what mandated Ms. Myeni, acting in her individual capacity as chairperson only, what mandated Ms. Myeni to issue me that instruction to not sign the MOU and cause financial harm to the company.
We'll get
that
to
I still don't know.
We'll get to
That's what I don't know.
What somebody who does know is Sylvain Bosk, and he articulates reason on email. Will testify. Yes. Yeah, but he's written why he thought the chair was disagreeing. And to deal with that point as well, is that this, based on your 6th of July submission, which should have been gone to a board vote, she could not have a single veto power. Why have a resolution?
My lady, the only response I can have is the actual letter of the actual SMS, the WhatsApp that is in evidence.
But I'm saying to you, legally, what was possible?
Yes, my lady, I agree that certain illegal actions were taken in my view.
I didn't say any illegal actions were taken. I'm asking you, legally, was it possible for the chairperson? My lady, I've got a problem with counsel here, my lady. She's communicating with the witness. She's shaking her head, she's nodding, she's shaking her head throughout the time, my lady, and I didn't want to be petty about this issue. But before I've even finished the question, she's shaking her head, my lady. I don't know what my lady makes of that issue. Yes, ma'am.
But I didn't give, she was shaking her determined. I didn't, my perception from where I was sitting was not that she was shaking that with me, she was shaking it in general. But Ms. Steinberg, for as far as it is possible, please do not shake your head any further.
I'll do my best, Lady.
I didn't want to be petty, but I've been observing it for some time, my lady, and it creates a problem. Thank you, my lady. The issue that I was trying to get through is the following, is that legally, was it possible for one member of the board to block this MOU?
My lady, it should not have been possible to do so legally. I would, however, say when the one person is the chairperson of the board who claims to be conducting actions on direct instruction of the then president, it does take on a different cloak.
We'll get to that. But anyway, let's move to page 218. It's a letter dated 9 September. Do you see that?
Yes, my lady.
And there we see Mr. Zakele Twala, Deputy Director General, Civil Aviation. That's his title, right?
Yes, my lady.
Now, this is not written by yourself, so you may or may not have a view on it, but I want to just show you one point in it. And it's titled Department of Transport Litigation Against Emirates. You see that?
Yes, my lady, I do.
Right. I'll start at the second paragraph. Reads as follows. As SAA, we are indebted to the DOT for the ongoing support it continues to receive in its efforts to turn around its operations and business. As you are aware, we have been engaged in commercial discussions with Emirates, which we envisaged will unlock significant value and play a critical role in addressing the challenges faced by SAA, in particular regarding our intercontinental operations. You see that?
Yes, my lady.
Now, sorry to drag you through this because I need to get to the last sentence, but it all provides context. It says the following in the next paragraph. Although some delays have been experienced in the finalization of our internal sign-off processes, the proposed strategic cooperation with Emirates remains a matter of great importance to SAA. Whilst we are aware that any decision regarding the continuation of the litigation against Emirates is a matter for the DOT to opine on, we believe that halting the litigation would facilitate more productive discussions between SAA and Emirates as a sign of good faith to our counterparts of the seriousness with which we regard the conclusion of the strategic cooperation. Accordingly, we respectfully propose that the litigation against Emirates come to an end to allow us to engage in a spirit of collegiality and good faith. Do you see that?
Yes, my lady.
Now,
I
this
do.
was after your time at the airline.
I do, my lady, but I think that factually, well, the first part of it stating that there were internal delays on internal sign-off, specifically failure to sign the MOU, I concur with that statement. The statement that reiterating that it's the DOT's prerogative to opine on whether they take legal action or not is wholly consistent with my statement of yesterday. And to the extent that SA is discharging its duty in terms of the unsigned MOU in this case, of providing support, they've discharged their duty in this instance. So, yes, I take note of this content. I do concur with you that it was post my tenure and I was not aware of this writing and correspondence, but I can see the logic and it's cogent.
Now, what did happen during your tenure, though, is the following. Is that on the 6th of July, you brought a proposal to the board to sign the MOU. Is that not correct?
The 6th of July being one of those dates, and with multiple dates before. Yes, my lady.
Now, the MOU,
And it's for that my apologies, my lady. It is for that very reason that I state I can concur with the first statement that although some delays has been experienced in the finalization of the internal sign-off process, the 6th of July being one instance of it, and there were others.
you see, what is interesting here is that the MOU you submitted for signing in July is different to the one that you wanted to be signed in June. Is that not correct?
They were very marginal. My lady may point me out to the differences.
Okay. The one MOU is at starts at page 135. The first MOU is at 135. Yes. Then the next one is at 1928. Thank you, madam. Sorry, my lady. I beg your pardon. I've compressed all my bundles into a single one just for practicality reasons. Sorry. 1928. You see? Now, we're going to have to flip between the two. And I'm saying there were changes. However, you may not, I agree with your point that not to the core of the document, but it was edited. My lady, my stickers have fallen out those tabs. Can I skip this question and get to it later? Because I'd marked it, I'm realizing my stickers have just fallen out. Okay, thank you. Thank you. Right. Now, let's get back to the events in Paris. It was your evidence that this was due to be signed at the Paris Air Show. Is that not correct?
My lady, it's my evidence that that was at least the second attempt to get it signed, yes.
The question I ask you now is, prior to the Paris events, was there a board resolution to that effect?
My lady, a board resolution to what effect?
To say that this may be signed in Paris?
No, there was board agreement. Firstly, my lady, no board resolution was required. May I finish, my lady?
No board resolution was required.
No board resolution was required to sign the MOU. What was required was agreement by the board members. All board members at that point had indicated their agreement. Ms. Myeni refused to give her agreement.
How do you capture board agreement?
It could be in minutes, it could be extracts out of minutes, it could be a written correspondence. In some instances, it may be a situation of a verbal agreement or verbal indication from a board member, which I would thereafter then commit to writing and send to the board member and state and recall, this is the discussion we had, this is what we agreed. For good order, I'm committing it to writing. Nowhere in SAA's constitutional documents is the right or the requirement for a non-binding MOU to be executed in the behest or in the power of the board. So therefore, there is no resolution, there's no process defined for a non-existing right.
The question then I ask you is, on what basis then do you submit a request for board approval on the 6th of July if such rights doesn't exist?
It's simply common courtesy because the board had been involved in the process and Ms. Myeni placed it apparently important enough for her to meet with multiple ministers or state that she would meet with multiple ministers, and the fact that the chairperson of the SAA board gave me a direct instruction. And we tried multiple times to discuss this. In good order, it's useful to have a board aligned, to have a board understand the strategic steps that you're taking, and therefore we applied a tremendous amount of effort to make sure that the board is fully aware, fully appraised, and fully on side with this initiative. And we ultimately succeeded with the exception of one individual.
Just
My lady, typically for any board of directors, there would be a terms of reference, and there would be, for example, an MOI, and alternatively a shareholders compact, the governance documentation that we discussed on Friday. That would define what rights and rules and responsibilities, obligations and accountabilities individual board members have, or the board has, not individual board members, but the board. It would also contain prescripts of what matters are reserved for the shareholder. So, for example, it is typical in public companies, not state-owned companies, but public companies, that the board of directors of a company will have sole authority to appoint a CEO, for example. It is, however, typical in state-owned companies that through the shareholders compact, the state will state that the shareholder, being the state, must have an involvement in recruiting and appointing a chief executive officer. So SAA has got similar documentation in place in terms of references of a board, an MOI, or alternatively before that an Articles of Association, and that would define what the powers and rights are of the board. The board can, over time, change some of these rights because the board delegates authority to management. So as testified on Friday, the board, for example, never before had a right to dispense funds and incur expenditure on behalf of the company. After I left, the board enacted and changed the company's procurement policy to give the board the responsibility and accountability to directly expend funds on behalf of the company. So a board can change its rules and conditions within reason, and there are legitimate reasons why boards may do that, but they would do that in a formal and a structured manner. So in terms of a delegation of authority that vested in the CEO of SAA, that delegation of authority to the extent of executing non-binding MOUs was never withdrawn from the board or from the CEO. So in the first instance, the board has got all the rights and all responsibilities, all accountabilities. Then it delegates. It can change that delegation over time, and the ability to sign a non-binding MOU was never undelegated to the CEO and therefore falling in the behest of the board.
Why didn't you just wait ahead and sign it before
My lady, in hindsight, that's exactly what I should have done. Ms. Myeni had no legal right to stop us from signing this MOU. I was intimidated in the process, and in hindsight, if I could do it again, I would have executed the MOU after receiving majority board approval. Because there's also, there's what's in policy and procedure, and then there's also a spirit. So in the way that I manage a company normally is I'd want to take my board with me. I take my board as counsel, and if my board members tell me or give me direction and say don't do this, or here's my advice, here's my guidance, I should take that guidance. But I should also understand what the reasons was. Now, specifically in this case, the one board member, the most senior board member who was politically connected, made statements specifically saying that she has got a fear. I was given 2 reasons, which may or may not be the valid reasons, but those reasons did not make sense to me whatsoever, and today is potentially being disclaimed. So, yes, in hindsight, I should have just executed the MOU.
That was the correct position. You could have just signed it, but the problem you still experience this one issue is because, and I'll take you to the deliberations of this team thereafter, is that there was one issue in this MOU which posed a risk to the binding nature of this MOU. And the issue, consistently in all correspondence, is about the fact that this MOU spoke about the 4th frequency. Now the question is, could you have bound SAA to say, we will give Emirates to the right to continue with your fourth frequency.
My lady, I don't know whether or not this is an honest mistake or is it intentionally phrased as such. The MOU at no point states that SAA will give rights. And again, at the risk of belaboring a point that was belabored to death yesterday, SAA cannot assign rights. SAA nowhere commits to assigning rights.
In the memorandum of understanding, was this dealt with?
Yes, my lady. It specifically says in the memorandum of understanding, it states that SAA will provide support, regulatory support, which yesterday we had a long segue on the binding nature of the MOU. Now, having reread the MOU last night, the binding nature of the MOU extends purely and simply to the stock standard provisions that are typical: confidentiality, regulatory compliance, which, by the way, is simply there for SAA's benefit, and the remainder, none of it is in substance. And the obligation for SAA to provide Emirates with bilateral support is not one of the clauses that is binding and survives the MOU.
Well,
So therefore, to your question, my lady, would I, by signing the MOU, have indefinitely bound SAA to provide Emirates with regulatory support? No, I wouldn't. It was not a clause that survives.
Well, that's not what Emirates says.
I accept that that may, whatever, I can only speak to the contents of the MOU. My lady, your question to me was your signature to the MOU going to bind SAA? And my statement is specific to that, in as far as the MOU. And the MOU are here for interpretation by legal practitioners, like it was interpreted by Ms.